Hi, good morning. This is Rudran from Criminal Law Department. Today we are going to discuss about the basic outline of criminal law and the principles of criminal law. So before going into basics understandings of criminal law and principles of criminal law, one has to understand every government or sovereign state or any country its key important role in maintaining peace in the country in respect to maintaining the law and order, thereby it protecting the rights of every citizens. Okay, so it becomes a key challenge for every country or the state to protect the rights of the individuals or the citizens of the country. Okay, so the criminal law actually, it becomes a pillar in maintaining, protecting the rights or maintaining the law and order in every country or every state. So we will try to understand what is criminal law. Criminal law is basically it talks about what is crime, okay, and what are all the types of crime, or what causes the crime, or what are the different stages of crime. It also discusses about the criminal offenders who commits crime. Okay, it also discusses about how judiciary intervenes with respect to criminal offenders, right from the investigation or the punishment, or after punishment, the restoration of the every offender into the society. It talks, in multi-dimensional way of, you know with respect to crime. So criminal law actually, broadly classified into two ways actually. One is substantive law and another is procedural law. The substantive law, it talks about the every individual's rights and liabilities with respect to from one person to another person actually. This substantive law also defines the different kind of offenses and also different types of punishments. Offenses, if you take, it can be a cognizable offenses, non-cognizable offenses, or punishment can be simple imprisonment or rigorous imprisonment or lifetime imprisonment or even death penalty or the capital punishment. So whereas if you take procedural law, if you take the different kinds of procedures which is need to be applied, it may be either the suspect of a crime or the convicted of a criminal offender, how the different agencies act with respect to the crime. The different agencies what we represent, it says that it may be a investigating officer, it may be a judiciary, it may be a council of advocates or defender. So anybody matters, how the different kind of procedures need to be established right from the crime occurrence of the crime until the judgment and the punishment or rehabilitation restoration with respect to the crime. Now we will try to see the different kinds of crime. Okay, so different kinds of crime. So crime can be a different types actually, or different kind. One may be a personal crime, so it is like hurt, assault, murder, or grievous hurt. These are the personal crime which is directly against human body. And another is actually property crime. So property crime can be a theft, robbery, dacoity, so where the property is been under damage. So if you see organized crime can be human trafficking, contract killing. Many examples are in organized crime. And economic crime is a very important thing. That is actually money laundering, tax evasion, or white collar crime. These are things comes under economic crime. Along with that, many other crimes also there actually. So we will try to understand what are the elements of crime. So elements of crime, if you see, there are important elements to consider it as a crime. So one is mens rea. Okay, mens rea is actually guilty mind. So this is one of the element. And actus reus. Actus reus is a guilty act actually. So when mens rea and actus rea meet together as an occurrence, it becomes a crime. Okay. So if you see, other than element, there are different stages of crime actually. So to complete the crime, there is a planning, preparation, and commission of crime. It leads to the crime. This crime actually, after the crime, the investigating officer finds out the real causes of crime, and investigating officers try to find out the real truth of the crime, and it goes into judiciary for the investigation. Trial procedure is started, and after the trial the judgment comes. After judgment, the offender gets punishment by the way of conviction. After the conviction, he gets punishment. After punishment, he comes back to the society. So he comes back, he has been given the like rehabilitation or kind of reformation. It has been given actually. So these are different stages of crime when it comes. So now let us try to understand the criminal law with respect to Indian context. So if you see Indian context actually, Indian context, so criminal law, there are about three important acts which is comes under the criminal law actually. The one is Indian Penal Code, currently Bharatiya Nyaya Sanghita 2023, and CRPC, Code of Criminal Procedure Code 1973, now it is Bharatiya Nagrik Suraksha Sanghita 2023, and Indian Evidence Act, it is Bharatiya Sakshiya Adhinayam 2023 actually. So if you see actually in Indian context actually, criminal law falls under criminal law, and criminal procedure law falls under concurrent list of Indian Constitution, which is under the Schedule 7. The concurrent list of both criminal law and criminal procedure actually, both state government and central government can enact law with respect to criminal act. So other than these three act which is specified actually, there are many other special act which also comes under criminal law to ensure fair, right criminal justice system. That is actually example, Domestic Violence Act, Sexual Harassment at Workplace Act, or even POCSO, and many other special act which comes under the criminal law. So now we will try to understand the basic criminal law exists how long. The criminal law can be traced since from the ancient period actually. So ancient period, if you take 1500 BC, the criminal law exists actually. You can refer through Manusmriti, Dharma Shastra, Artha Shastra. So in this code of conduct, so we can see the criminal law. So later to this ancient period, the medieval period, during the Mughal period, there was an irrational punishment with respect to offenders. So there was draconian kind of activities being given by the Mughal period actually. So at the same time actually the British entered into India by the way of East Indian Company for the purpose of trade actually. So soon after British started gaining the power of administration, so they started conquering majority of the Indian places and princely states actually. So during that time actually the first law commission, which is formed in 1834 by Lord Macaulay, so he has drafted Indian Penal Code and adopted in 1860 and effected from 1861 actually. So followed by Stephenson actually drafted Code of Criminal Procedure Code in 1861, which is been adopted in the British Parliament, and followed by Indian Evidence Act, now Bharatiya Sakshiya Adhinayam. So these are things which ancient period, since from the ancient period, medieval period, and even like British period and post British period after Indian independence, the criminal law exists actually and made many changes and many reformatory changes in the criminal law actually. So now we will try to understand some of the important principles of criminal law. So before understanding the principles of criminal law, so India, we follow the common law system which was being followed since from British period, that is adversarial form of criminal justice system, where actually the rights of the accused is protected actually. So it is understood that actually there are hundreds of offenders can escape from the punishment, but there should not be single innocent should not be punished actually. So actually it becomes a big loophole for many offenders who escape actually, because we follow, our judiciary follow primarily on evidence based punishment actually. So if there is no evidence actually with respect to the offenses, there will not be enough punishment. So this is a kind of adversarial form of punishment actually. So we can refer some of the legal maxim actually. Actus non facit redum nisi mens itria. It says that actually no one can be liable for the criminal offences unless until it is prescribed in the statutory or the law or any act. So it means nobody can be punished actually without specified in the law actually. So now we'll try to understand the principles of criminal law. The first principle is principle of legality. So which is actually quoted actually the legal maxim, principle of legality. No person are liable for any punishment unless there is a prescribed in law actually. So these are one of the important principle actually, particularly at the time of offenses committed actually. So that is one of the important principle. And second important principle is a presumption of innocence. So presumption of innocence actually, any offences committed or suspected or offender, he has to be considered as a innocent till the guilty is proved beyond reasonable doubt. So this is actually presumption of innocence. So another important legal principle actually, the burden of proof always lies with the prosecution actually. The prosecutor has to prove the offences which is in concurrence with mens rea and actus reus. It is beyond the reasonable doubt actually, it is considered as a crime. So this is actually the burden of proof always lies with the prosecutor actually. So another important principle, that no person shall be compelled to accept his own crime. So which is actually described in Indian Constitution in article subclass 20, subclass 20 by 3. It says that no person shall be directly, self incrimination can be imposed actually. So another important principle is that there shall be no person shall be made double jeopardy. So as per the Indian Constitution, Article 20 subclass 2, it says that so no person shall be punished twice for the same offences. So these are one of the very important principles of the criminal law actually. So these are the the widely the important principles which is being discussed actually. And of course the criminal offender has a right to have a legal representative or the legal counsel. So he has to yeah. And another important thing is, once any offender who commits crime, he becomes criminally responsible. He has to be punished by the judiciary by the way of judgment. So these are the some of the important legal principles of criminal law actually. So hope you understand, and thank you very much.